Standing here with Professor Doug Colbert. He's with the University of Maryland School of Law. And Professor Colbert, thank you very much. But what did this case reveal about city policing and the relationship between the city police and prosecutor's office?
Well, it's going to take a very strong prosecutor to follow the evidence and to bring charges against a police officer. But that's her ethical duty, where the evidence supports conviction, in her opinion, beyond a reasonable doubt. The prosecuting attorney must do so. No doubt she's already felt a great deal of the wrath and hostility from the police union. But I expect that there will be additional trials because you're putting the police department on notice. You're putting the officers of their awareness that they must treat people and protect them and safeguard them and make sure that what happens to Freddie Gray does not ever happen again in our city.
Marilyn Mosby has been in the courtroom on and off throughout the entire trials. Today, however, some of her staff was in the courtroom, but she was not. Make anything of that?
No, I think what's important here is that she has maintained her commitment and her dedication. A lesser official, perhaps only thinking about their future, might have decided to take a different path and to do what the police union is requesting. But I think we can feel certain that the prosecution will continue, but will try to add the missing pieces that Judge Williams identified during his decision.
You've been sitting in on all these trials, and this one included. Was there enough evidence to prosecute on anything, and if so, where?
Well, the judge indicated there was enough evidence when he denied the defense motion to dismiss at the close of the prosecution case, and he found that there was sufficient evidence on 3 of the charges. So that's the answer to any of the naysayers who are questioning whether there was sufficient evidence. The question, though, for the judge was it sufficient to prove guilt beyond a reasonable doubt? And for the court, he found that there was not sufficient evidence.
The judge said apparently there were too many gaps in the state's case, and the judge said the court's imagining is not a substitute for evidence. That was a clear signal to the judge. You guys have got the same evidence, but you're going to have the same conclusion unless you present it differently or come up with something new?
So one place where the evidence can be presented will answer the judge's question about the awareness of the police defendant, that the defendant was aware that placing Freddie Gray in the situation he was in left him helpless and vulnerable to injury. And that evidence, Dave, will come from our city paying millions of dollars for other people who were seriously injured during police rides. And that information, I expect, would have been communicated not only to the top of the police department, but to the officers on duty.
Now, final question here, though. You know, part of that evidence that did not come in was a sanction for a discovery violation, and that evidence could have been records outside of the academy training. Did that make a difference now in hindsight?
No, I think that the prosecution expected the judge to take notice that 18 years on the force in the position of a lieutenant would have given this particular defendant the awareness, the knowledge that he needed to know that he must seatbelt, and that injury would likely, or the potential of injury would have likely occurred.
Thank you very much, Professor Doug Colbert, University of Maryland School of Law. Let's go back to you.
All right.